Hi, I'm Robert Ottinger, and I'm an employment lawyer. At my firm, the Ottinger Firm, we've been representing employees for over 30 years. Today, I want to talk about retaliation or whistleblowing, one of the most common cases that we see in Los Angeles. Those two things, retaliation and whistleblowing, really mean the same thing. It comes down to a person who gets fired for complaining about something at work. There's several laws in California that protect people who complain about or report potential illegal conduct. The law in California goes to great lengths to protect people who have the nerve to stand up to their employers and make complaints, because those people deserve to be protected. In fact, those cases actually get the highest jury verdicts of any kind of case in the realm of employment law. So who does it cover? Well, in Los Angeles, it covers pretty much anyone who complains about potentially or actual illegal conduct. For example, if you see someone at work who's being sexually harassed or the victim of discrimination, and you complain about it and you get fired, that law will protect you. Or if you feel like your rights are being violated and you complain about it and you get fired, it also covers you. A lot of people we see are victims of discrimination or sexual harassment. They go to the company for help and they wind up getting fired. Whistleblower is very similar. That covers people who make complaints about illegal conduct at work. Maybe they think there's some kind of fraud or tax fraud or violations of environmental laws. It can be almost anything that's illegal. If you see something that you think is illegal at work and you complain about it and get fired, you would be protected by this whistleblower law. California recently passed a law about a year ago. It says that if a person is fired within 90 days of reporting illegal conduct of any kind, there will be a presumption of retaliation. So this is a really good thing, because in these kind of cases, what the courts look for is something called temporal proximity, which is closeness in time between the reporting of the illegal conduct and the adverse action, which is usually firing. If that happens within 90 days, there's a presumption that you were fired for reporting the incident. If you live and work in Los Angeles for a large company, or even a small company, and you see something that's illegal or even potentially illegal and report it and get fired or demoted or otherwise punished, you may have a case. It doesn't matter if what you report is actually illegal or not, as long as you believe in good faith that it is. You know, we're not all lawyers. You see something that you think might be illegal and you report it and it turns out it really wasn't illegal in the end, but you still got fired for it, you'd still win the case. I hope that helps you understand this important law that protects everyone in Los Angeles and even throughout California. If you think you've had your rights violated, please give our firm a call.